Attorney General almost 30 years ago, 25 years ago, first time around in the first Bush administration when you were, what, 15 years old, something like that? Was it? Yeah.
41, yeah.
You're back.
Let me just say that my view on this thing is that the only people who should be Attorney General are people who are too young to know the risk or too old to care.
Well, we won't decide which category you're in, but just what's your, and then you worked in the private sector, you've talked about it a little bit for most of that interim period. As you come back into the, you've obviously been somewhat hit by all these impeachment and other related issues and investigations and everything else, but as from the point of view of business, what you've seen from outside the Justice Department, from outside government in the last 20 years or so, what do you want to do, and you've doubtless had to deal with the Justice Department in various roles in many ways, what do you want to do, what needs to be done, do you think, especially from the perspective of this business audience, to make that experience of dealing with law enforcement fairer, more effective, maybe more transparent? What are your priorities there?
So my view is you shouldn't work in a senior position in the Department of Justice unless you've spent a lot of your time on the outside dealing with the Department of Justice. So a number of things. Number one, time. I think there's a risk at the department and other agencies, they think they can take forever on their matters, and they do, and they come in, sort of like day after day in the case, or it's like their rice bowl for the next 5 years, this investigation. My attitude is fish or cut bait. The government, that has huge cost to the government in terms of opportunity cost for you to be, excuse the expression, dicking around with some case that really isn't getting anywhere. And it's very costly to the private sector to be under this kind of cloud. So I want to make sure that people purposefully address a case. There's someone who's sensible who can look at it and say, is this going to get anywhere at the end of the day? Are we going to be able to prove a crime beyond a reasonable doubt? And if we're not going to be in that position and it's disproportionate amount, are we going to move on to the next thing? So I'm impatient with, sort of the backlog of cases and the average life of cases. Another issue is, esoteric legal theories. Enforce the law in the core meat and potatoes area where the law is supposed to apply, and don't come in here with some kind of esoteric application of the law just because you can catch the company. The other thing is, let's face it, companies are like shooting fish in a barrel. Very few companies are going to go and take the risk of a trial. And so over the years, a state of mind has arisen where, you get the company over a barrel, you just get, it's a question of how much money you're going to get. And so we've adopted the policy that in order to come in to resolve a case, the prosecutors have to come in with a trial plan. They have to show that they can establish beyond reasonable doubt all the elements of a crime and what witnesses they're going to be able to call to do that. They're going to show they have to do the work to say that we can prove beyond a reasonable doubt that this company is guilty. Now, if a company rushes in, the day after they're caught and says, hey, man, we want a DPA and, we're willing to pay anything, I'm not saying that we wait until we develop the case. Okay, you want to deal, we'll deal. But if a company's being held up on something that's unjust, we want to put the prosecutors through the ringer that they actually have to have the evidence and be able to prove beyond a reasonable doubt, rather that this is not an extortion of the company. Those are some of the ways that I'm trying to address it. Now, there's a lot going on, and I can't give this my undivided attention, but this is one of the reforms I'd like to see.